All right, we are trying this for a third time, this time using a laptop. So BJ is now on the other side of the room and we'll be kind of rotating for the remainder of this presentation. So I believe that the prior attempts are not saved. So we'll just start from the top. My name's Koral Alman. I'm an attorney here at the Van Winkle Law Firm as part of the Trust and Estates and Elder Law Group. This is the second Facebook Live video in our 8-week virtual Lunch and Learn series. And today we're going to talk about what is probate, the basics on what to do after a loved one dies. So our plan today, God willing, is that we will walk through a quick overview of the probate life cycle and the steps involved with the probate process. Then we'll go through some common questions that BJ and I often get from our clients about that process. And then if time permits, we'll also work to answer any questions you leave for us in the comment section. So the first step in the probate process often involves the funeral home. Here in North Carolina, they will assist you with getting certified death certificates from the Register of Deeds. There's usually a waiting period for that, at which time we often meet with clients to discuss the whether a formal probate administration is needed. That is often dependent upon the types of assets that the deceased owned, as well as the formality of their estate plan. BJ is going to talk a bit later about the types of assets which pass through probate or outside of probate, and how those assets end up getting distributed to the heirs or beneficiaries. So as an initial matter, let's talk about what is probate. In its most technical sense, the word probate just means that we are trying to prove the validity of a will. But the way folks regularly use it is to describe the estate administration process. That's the process where an executor or an administrator or a personal representative, those terms are not exactly the same, but we'll use them a bit interchangeably today. That individual gets appointed by the clerk, works to collect the assets of the deceased and distribute them out to the beneficiaries or the heirs of the estate. In North Carolina, that process is overseen by the clerk of court in the county in which the deceased was domiciled, or in a less technical term, where they resided. The clerk serves as the judge of probate and oversees and is involved throughout the entire probate process. So I'm going to pass it off to BJ, and he's going to talk to you about some broad concepts relating to the probate process.
Thanks, Koral. So we're doing the handoff here kind of the old-fashioned way because of technical problems, as everyone has seen. But picking up on where Koral left off, basically there are two forms of estate administration, two different types, basically. There's what's called a testate estate administration and an intestate administration. Our colleagues Melody King and John Kelso spent some considerable time on Tuesday going over those, and so I don't want to go into as extreme detail as they did. That's still available on our Facebook Live or Facebook account for people to review. But I will talk on that a little bit. And basically, for our purposes here, an intestate estate is simply just an estate where someone has passed away and does not have a will. And in those circumstances, North Carolina law governs the questions of who is going to receive what, how much they're going to receive, and actually also who has priority to serve as the administrator of the estate, the person who is entitled to collect the assets of the estate, to pay debts and expenses of the estate, and also to distribute property of the estate and make court filings when necessary. We usually help advise clients through that process. And really those questions in an intestate estate, meaning who is going to receive what and how much and who has priority to serve, are largely going to be governed by that individual's family circumstances. Are they married? Do they have children? Do they have kids?
It's not broadcast.
Oh, it's not broadcasting?
Yeah, I don't know.
Should I end live video?
That's live. Oh boy. I've been sharing it with people.
Should I end it?
I maybe just keep going and then we'll keep going.
So unsure whether we're live or not, but I'm going to keep going at this point. So those questions are determined by the family circumstances. Attorneys like me often will joke, essentially, that if you die without a will, the state of North Carolina has already provided one for you. The good news is there is a plan in place. The bad news is it's usually not going to match what your intent would be. In fact, I've never been involved in a situation where it exactly matches that individual's intent. I would also, just as a technical point, say that you'll hear us talk about an administrator of an estate an executor of an estate. They're basically the same thing substantively. The only difference really is that an administrator is the term used to describe somebody who is in charge of an intestate estate, whereas a executor is in charge of a testate estate, which kind of leads to the next form of administration, which is testate. And you've probably already gathered that that is a scenario where an individual has died and does have a will. In that case, the terms of the will govern those questions that we talked about just a moment ago. Who is entitled to inherit, how much they're going to inherit, and also who would be named as the executor of the estate. In that case, the will and the North Carolina law, North Carolina general statutes will govern the process of the administration. And one of the things that you can do with a will as opposed to an intestate administration is potentially lower some of the administrative hurdles and barriers that your executor may face, like waiving a bond requirement. However, there are many different cases and many different situations where a lot of the assets of an individual's estate are going to pass outside of probate. And so I want to talk a little bit about a distinction between what are, we call probate assets versus non-probate assets. The difference really is that for a probate asset, that is something that is subject to the terms of your will, and the disposition of it will be governed by the terms of someone's will. Example would be a bank account in someone's individual name, no beneficiary designation. The terms of that person's will are going to control who inherits it. And then there's non-probate assets, which are really types of assets, accounts, property that are going to pass to individuals or entities without having to go through the probate estate because of the form of ownership or because there's a beneficiary designation of some sort attached to it. Some common examples of non-probate assets versus probate assets would be, starting with non-probate, a type of retirement account, like an IRA or a 401k that has a beneficiary named or beneficiaries named other than the estate. Similar, a life insurance policy that has beneficiaries named other than the estate. A bank account or an investment account that is either jointly owned with a right of survivorship and passes directly to the co-owner, or has a transfer on death beneficiary named. Real estate in North Carolina most of the time is going to be a non-probate asset. I'll touch on that a little bit more later. Assets held by a trust, for example, a revocable living trust, that's largely a substitute for a will hold those assets, and because it's not in the individual's name, will also avoid probate. And lastly, even a car, as long as it was held jointly with a right of survivorship, would avoid going through probate. And then there's probate assets. Simply put, probate assets are generally going to be any individual asset, individual account that is in someone's name, not jointly owned, and does not have a beneficiary attached to it. Example would be a bank account, like I mentioned earlier, that is just individually owned with no transfer on death. Even a life insurance policy or a retirement account, if there's no beneficiary named or the estate is named as the beneficiary. Your stuff, personal property, belongings, things like that, generally are also going to be a probate asset. Business interest would fall in that category as well, as long as it's not owned by a trust. And even a car is a good example. An individually owned car or even a jointly owned car where there's no right of survivorship. That covers a lot of ground, and so as you probably ascertain, non-probate assets are pretty important, and so during the planning phase, it is very important that you plan and account for those types of non-probate assets and make sure that your will or your general estate plan is cohesive with these non-probate assets, and that you have named beneficiaries or titled property appropriately so that you have a comprehensive plan and there's not inconsistencies. Non-probate assets generally are great. The transfer of those happen fast, quick. You do potentially avoid some cost or delays through the probate process. However, sometimes the rush to avoid probate can create situations where you have created further problems by failing to properly put a cohesive plan in place. So with that, I'm going to hand it back to Koral. She's going to slide in, and I will be back soon.
All right, folks, thanks for bearing with us while we had some technical difficulties this morning. I believe we are now publicly live, and if not, it will be posted to our page later this afternoon. So I'm going to talk briefly about the procedures involved with the court, the clerk of court, as you process probate or go through the estate administration process, as we would refer to it. So we will regularly meet with families and kind of review if there's a will, what the intended estate plan is, and if there's not, we walk through what the intestate statutes dictate should happen to the deceased's assets. We will then, assist with the process of applying to the court. So your will appoint who you would like to serve as an executor of your estate, but you need to then qualify that individual with the clerk of court. And so we will assist clients with the preparation of what we refer to as qualification documents, the set of documents that you need to present to the court in order to get qualified to serve in that role. At that time, the court will issue a document, either known as a letters testamentary if there was a will involved, or letters of administration if it was an intestate estate. That's the document that gives the personal representative the authority to act on behalf of the estate. It lets them access bank accounts, close those accounts, open an estate account, transfer a vehicle out of the name of the deceased into either its new beneficiary or to sell it, depending upon the case. It also helps with the transfer of stocks. It's just generally the document that you need in order to file tax returns or do anything on behalf of the estate. It's important at that time for the personal representative to evaluate what the deceased individual actually owned. As BJ talked about, you can own assets in a myriad of different ways, either individually, jointly, or with some sort of beneficiary designation. So once an individual is appointed as the personal representative, it's at that time that they really work to ascertain what the heck did they own and how was it titled? Does it need to pass through the estate administration process, or does it pass automatically? About 90 days after an individual qualifies as the personal representative, they need to file an inventory with the court. That's a document that we regularly assist clients with the preparation of because it requires very detailed accuracy as to the value of the assets owned either in the estate or that may be available for the payment of creditor claims. Once that document is prepared and filed, we will also, or rather, while we are in the preparation of that document, we also work to prepare a notice to creditors, which is run in a local newspaper, and it's the process by which we are really ascertaining if there are any creditors out there to whom the decedent owed funds. Alternatively, we can also ascertain if the decedent was owed money by another individual in that process. We also work with the executor or the personal representative to obtain a tax ID number and assist with the process of opening an estate checking account or an estate brokerage account, as the case may be. As part of the estate administration process, that executor is going to need to transfer the assets that were owned in the decedent's individual name into an estate account. From the estate account, they get transferred out to either the beneficiaries of the will or the heirs if it's an intestate estate. It's a very detailed process here in the state of North Carolina. BJ is going to talk a little bit more about the process of paying debts and expenses and distributions from the estate. But I just want to note broadly that at least once a year and then at the end of the estate administration, you will need to file an accounting to the court. And that's a very detailed accounting that requires accuracy as to every penny that comes into the estate and every penny that goes out. So we always like to reiterate to clients the importance of maintaining good detailed records. Both bank statements, canceled check images, invoices for any expenses that are paid, as well as the documents that BJ is going to go over that are required for distributions. So I'm going to pass it back to BJ, and we'll make our loop again.
All right, thanks, Koral. So continuing on from kind of the topic that she was discussing in the life cycle of an estate administration, where I'm getting to now is once the assets have been identified, once they've been collected, at that point, the next phase of the estate administration is making sure that debts of the estate and claims of the estate have been paid off. So during that process, we're typically helping clients with, number one, determining and identifying what claims and debts are out there that need to be paid and determining whether they are legitimate or not. Then determining when and how to pay those. During an estate administration, there are certain debts, certain creditors that have a higher priority than others. And so usually you want to make sure that you're paying those in order so that you don't inadvertently pay off a creditor first who had a lower priority and be left with little or no money to pay off somebody that should have been paid first. Also, generally speaking, during this process, we're usually recommending to clients that they wait to satisfy debts and claims of the estate until after that creditor's period has expired, so after 3 months from the publication date, so that we have a full picture of what the assets are, but also particularly what the debts are. And then lastly, we're assisting clients gather the paperwork and make sure that we're getting paperwork back from the creditor so that we can ultimately file a satisfaction of their claim with the clerk of court's office and make sure there is proof that a debt has been paid off. Jumping on again, kind of to the next phase of the estate administration process, and one that most folks are probably the most familiar with, is after debts and expenses have been paid and you've identified the assets, next comes the process of actually distributing assets of the estate. And it's not entirely linear, meaning that some of this overlaps with each other, but generally that's the next phase. And there are some things that clients need to be aware of, particularly that there are different types of distributions or different types of gifts that may be provided for in the will. You may have a will that says, I give $10,000 to my nephew, or I give my 2006 Toyota to my niece. Those would generally be referred to as specific gifts, and those need to be paid priority-wise before the remainder of the estate is distributed. And an executor or an administrator needs to be aware of that when they're going through the process. Those kind of, for lack of a better word, come off the top before everything else gets divided. Normally in a will, you'll also have what's called a residuary clause, which is a kind of a fancy word for everything else or the remainder, which will have some provisions and state that after those specific gifts come off the top, after debts and expenses are paid, the remainder gets distributed to the individuals named, maybe a husband or a wife, a spouse, or children, whoever it can be, really. Whatever the type of distribution, it is important during the administration process that you receive an acknowledgement, a receipt essentially from the beneficiary that they have accepted and received the distribution that they were entitled to. That will be important at the time that you file an accounting with the clerk's office to prove that the beneficiary received their share of the estate and that they are satisfied with that. That has to be documented. Which leads to the accounting part of this, which is kind of in the life cycle of an estate, usually towards the very end. There's what's called a final accounting, which is when you're ready to close the estate, all distributions have been made, and the estate should have 0 assets in it at that point. And then there's an annual accounting, which happens if you're not quite ready to close the estate yet, and it's been open for a year. Essentially what the accounting is a very detailed report of all of the assets, all of the property that has come into the estate during your time period, and everything that has gone out of the estate during that time period, to the penny. And that would include things like interest on an estate bank account. So, the big takeaway there is you have to have documentation as well to support your accounting report. The clerk's office will review that and ask questions about it and maybe even kick it back to you if you don't have everything that you need. So you need to have the documentation there to prove the report that you're making. And so for an executor, for an administrator, you need to be very cognizant and aware that you are keeping detailed and accurate records along the way. A little bit of an aside, but still very much a process in the estate administration phase of this, is how taxes are dealt with in the context of an estate administration. We are, from the very beginning, meeting with clients and discussing taxes with them. There are usually at least 1, maybe 2, 3, or even 4 tax returns that would have to be filed during an estate administration. For an individual, they are usually going to have an individual income tax return due the year after their, or the year of their death. So if someone had passed away October 1st, 2020, they would still have an individual income tax return due for any income that they earned from January 1st, 2020 until the date of death. And that gets filed in April of 2021, just like your normal tax return would be. There may also be what's called a 1041, an income tax return on behalf of the estate for income that is generated after the date of death. And then in some some cases, not as many, but particularly valuable estates, you may also have to file what's called an estate tax return or a 706. But regardless, we are meeting with clients, discussing the need to file those tax returns, the deadlines, sometimes filing those tax returns on our own, on behalf of the client, and then other times working with their other tax advisors or CPA, make sure that everything gets filed appropriately. So with that, we've kind of run through the life cycle of an estate administration, and Koral and I are going to, in some form or fashion, talk about some general questions and concerns that clients often raise with us.
So we had imagined that BJ and I would be doing sort of a Q&A situation when we foresaw us being on a split screen, but now we're kind of in a different dynamic. So what I'm thinking is I will answer a few of the questions that we had talked through. I know there are some questions that we got in the comment section, and we'll also work to get those done. I know we're coming up on that 12:30 timeline, but we're going to probably run a little bit over given our technical issues on the front end. So one of the big questions we often get as part of the estate administration process is what happens to the house? Do I need a deed to transfer mama's house from mama to the children, or does it need to be a deed from the individual to the estate, and then another deed from the estate to the beneficiaries? And the answer to that is no. This is an important wrinkle of North Carolina law. Title to real property automatically transfers or vests in the beneficiaries of the will or the intestate heirs if there is not a will. And it's retroactive back to the date of death. So what that means is we don't need a deed in order to transfer title of that property from the individual into their beneficiaries. It occurs by matter of law automatically. The other important wrinkle of that is we were talking a bit about expenses being paid from an estate. But because this property, and I will add the caveat that there are ways that in your will you can direct that property pass through an estate, but without that express directive, it would pass automatically to the beneficiaries, which means that any of the costs of maintenance of that property are not proper expenses of the estate. The flip side of that is any income generated by that property, rent or probably just rent, would be payable to the beneficiaries directly, not into the estate. It's an important distinction that is often confusing to folks. So it's important to talk with your attorney at the time that you're dealing with an estate administration to really get that part clarified. The other question that I really want to touch on right now is people often talk about the goal of avoiding probate. And avoiding probate is not always the right strategy for every client. A better perspective might be to try to minimize probate. The reason we don't love to advise that we should avoid probate is that there are some assets that are very difficult to maintain in a non-probate form. For example, if you had a vehicle titled in the name of your trust, sometimes it's very difficult to get insurance on that vehicle, or very expensive to get that insurance. There's also benefits to probate, including the creditor period that we talked about, which helps ensure that all creditors come forward during a specified timeline. It's kind of a good way to shake the trees and see what's out there that might be owed. To that end, I believe there was a question about if I own everything jointly with my spouse, do I need to open an estate? And that's obviously a very fact-specific question, but an important consideration of that is, do we have concerns about there being a lot of debts owed or creditors out there that we either know or don't know about? And there might be a real benefit to running that notice to creditor to find out what's out there and how much they are claiming is owed. I'm going to pass it to BJ to answer a few more questions.
Sure. So a few more of the common questions that we get, and then I will also address some of the questions that have come in. One is if I'm dealing with an executor or an administrator of an estate, is particularly when it's going to be a pretty rough estate, is can they be compensated for serving in that role? The answer is yes, and even if the will says nothing about it or there is no will, generally speaking, and this is in the discretion of the clerk of court, an executor or an administrator can be paid up to 5% of the probate value of the estate. That's a key word, because if a lot of assets pass outside of probate, that value could be pretty minimal and there may not be much of a benefit in actually applying and receiving that, what's called the commission for the personal representative. The other thing I would note about that is going to be considered taxable income to the executor or the administrator that is receiving it. So a little bit of a caveat to how nice that might be to be paid. The last thing I would say about that question that we normally get is the will can change it. So although that the default rule may be you can receive somewhere between 3 and 5% of the estate assets, in your will, you could provide a particular percentage or a set dollar figure or something else in terms of payment. You may not want them to be paid. You may say they can be reimbursed for out-of-pocket expenses, but not actually paid. Another common question that we get is, what about someone who lives out of state and they have a piece of real estate, in particular in North Carolina? Does an estate need to be open in North Carolina in order to transfer that real estate to the intended beneficiaries? Normally the answer is going to be yes. That is called an ancillary estate administration. They can be pretty simple and straightforward. You would open an estate just as you normally would, except what you would primarily be doing is probating a copy of the will, or in an intestate estate, opening the estate and qualifying so that you pass title to that real estate to the beneficiaries named in the will or the intestate heirs. Sometimes you don't necessarily actually have to go through the process of administering the estate. You may just probate the will and pass title, but that would be typically in a scenario where there's no plans to sell that real estate for at least 2 years. I see that 1 or 2 questions have come in about cutting children out of their will. You do have the ability to do that. Children in North Carolina, really with one pretty minor exception, have no inherent right to inherit from their parent. And there's various ways to do that. You can just simply leave them out or state that your intent is to leave them out. The answer to that question really depends on the particular circumstances about whether you put some specific language about that in your will or not. But you certainly could. The answer is a little bit different when you have a surviving spouse. Surviving spouses do have some inherent rights, actually several. One's called the elective share, which would allow a surviving spouse, depending on the length of the marriage, to receive a percentage of the estate. And that is not just the probate estate. That would include non-probate assets as well. A surviving spouse may also have the right to receive whatever they would have inherited had their spouse died without a will, and even some rights to real estate in North Carolina. The public policy rationale there is really, we don't like for spouses to be disinherited. And so there's some protection in place for them, which can be waived by a prenuptial agreement or a postnuptial agreement or some other form of waiver. But compared to a child, a spouse does have some absolute rights that once they're waived, they can exercise. With that, I'll probably, sure.
I think we're probably coming up on 30
Okay.
minutes.
Yeah.
I'm trying to say goodbye to you all while we wrap this up, given our new format. But we'll endeavor to answer some of the remaining questions in the comment section. So, thanks, y'all.
Thanks.